He didn't look like someone who would become a problem. That was the first thing I noticed about him, how completely unremarkable he seemed for someone who would later change the entire direction of my life. His name was Daniel. He was 44 years old, a senior partner at a mid-sized commercial real estate firm in downtown Toronto. Educated, articulate. The kind of man who held doors open and remembered your coffee order after the second meeting. We met at a work function in the fall, one of those quarterly networking evenings at a rented space near King Street where everyone circulates with a glass of wine and pretends to be more interested than they are. I was 31. I worked in project coordination for a construction company, and I had been invited as a +1 by a colleague who canceled last minute and convinced me to go anyway. Daniel and I talked for almost 2 hours that night. He was funny in a quiet way. He asked questions and actually listened to the answers. He was recently divorced. He said 2 years prior, no children. He said that last part in a tone I now recognize as deliberate, establishing the record early. We dated for 7 months. It was not a dramatic romance. It was steady and comfortable and adult in the way relationships feel when you are past your mid-20s and past the part where you mistake intensity for depth. We cooked dinner at his condo in Yorkville. We spent weekends at his family's cottage near Muskoka. We talked about things that mattered. I thought we were building something. I found out I was pregnant in April. I was alone when I took the test. It was a Tuesday morning before work, and I sat on the edge of my bathtub for a long time afterward looking at the result. I was not trying to get pregnant. We had been careful, but not perfectly careful. And I understood that perfectly careful is the only kind that guarantees anything. I was not angry. I was not devastated. I was very, very still. I called Daniel that evening. I told him directly, because I am not someone who softens that kind of news with a long preamble. I said, "I'm pregnant." There was silence on the other end of the line. Not the brief, processing kind, the long kind. He said, "Okay." I said, "I know this is a lot to take in. Take the night. We can talk tomorrow." He said okay again and we hung up. He did not call the next day. He texted at noon and asked if we could meet Friday. I said yes. I went to work and focused on the task in front of me, because that is what I do when I am scared and I don't want to show it. Friday came. We met at a cafe near his office. He was already there when I arrived, and he had ordered his coffee but not mine. I noticed that. I sat down and waited. He told me he wasn't ready to be a father. He said it carefully, like he had rehearsed it. He said he had spent a lot of time thinking about it and he didn't believe he was in a place in his life emotionally, professionally, where he could give a child what it needed. He said he respected me, and he hoped I understood. I asked him what exactly he was suggesting. He said he thought the most responsible decision, given the circumstances, would be to not continue the pregnancy. I looked at him for a moment. He was 44 years old. He used the phrase responsible decision to describe ending a pregnancy he was equally responsible for creating. I told him I would think about it. I did not tell him that I had already thought about it. That the moment I sat on the edge of that bathtub, something settled in me. I am not going to pretend it was uncomplicated. It was not. But it was mine to decide. 2 weeks later, I told Daniel I was continuing the pregnancy. I told him he could be involved or not, that was his choice, but I would not be negotiating my decision with him. What I did not know yet was that Daniel was not the main event. Daniel was just the introduction. 3 days after I told him my decision, I received a phone call from a number I didn't recognize. The man on the other end of the line introduced himself as Gerald Daniel's father. He told me, very calmly, that he was aware of the situation. He said he had a proposal he thought I would find worth considering. He asked if I would be willing to meet. I want to stop here for a moment and describe Gerald, because I think it matters. Gerald was 71 years old. He had built a real estate development company from a regional operation in the 1980s into one of the larger private property portfolios in Ontario. Not a household name, but the kind of wealth that doesn't need to be. The kind that sits behind numbered companies and charitable foundations and sits on university advisory boards. He had the kind of voice that assumed it would be listened to, not loud, just certain. We met at his office in a building he owned, naturally, near Bay Street. I brought nothing with me except myself. He had 2 glasses of water on the table, and a folder I could see but could not read. He thanked me for coming. He told me he was a practical man and he preferred to address things directly. Then he slid a document across the table and told me his offer was $400,000. He said it would be transferred within 48 hours of signing. He said the agreement included a confidentiality clause and a release of any future financial claims. He said he had had his legal team review it thoroughly. He said he believed it was a generous offer given the circumstances. I looked at the document. I looked at him. I said, "So you're asking me to take money in exchange for ending my pregnancy and signing away my right to pursue child support?" He said, "I'm asking you to consider a practical solution to a situation that doesn't have to become complicated." I picked up the glass of water. I took a sip. I set it down. I said, "I'll need some time to review this." He said he could give me 1 week. He smiled when he said it. A controlled boardroom smile. The smile of a man who had closed a lot of deals and expected this to be another one. I walked out of that building, stood on Bay Street in the cold April air, and I called my friend Priya, who is a paralegal and the most clear-headed person I know. I told her everything. She listened without interrupting, which is one of her best qualities. When I finished, she was quiet for exactly 3 seconds and then she said, "Don't sign anything. Call a family lawyer today. Not tomorrow, today." I called the office of a family lawyer named Margaret Chen by the time I got home. Her assistant booked me in for the following morning. Margaret was in her early 50s, and she had the manner of someone who had heard every version of every story and was neither impressed nor surprised by any of it. She reviewed the document Gerald had given me while I sat across from her. She asked me several questions. She asked what province Daniel lived in. She asked whether I had any documentation of Gerald's offer. I had taken a photo of the document before leaving his office. She looked at the photo on my phone for a long moment. She said, "First, this agreement is not enforceable in Ontario. You cannot sign away a child's right to support. A child's right to financial support from both parents exists independently of any agreement between the parents. The courts have consistently held this." She said, "Second, what he's proposing exists in a very uncomfortable legal gray area and possibly beyond it. And third," she looked at me directly, "you have options he hasn't considered." She explained to me what prenatal paternity testing involves in Ontario. She explained what a claim for child support under the Family Law Act looks like for high-income earners. She explained that under Canadian federal guidelines, child support is calculated based on the paying parent's income, and that Ontario courts have discretion above the table maximum for high-income cases. She used the phrase table maximum, and I wrote it down in the Notes app on my phone. She told me that the first step, if I wanted to proceed, was to have the paternity established. She said she had a referral for a laboratory that processed prenatal DNA testing. She said once that was in order, she could file an application with the Ontario Superior Court of Justice. I asked her what she thought I should do. She said that was not her role to decide. Then she paused and said, "But I will tell you that in 20 years of family law, I have never seen a man offer money to make something disappear and then gracefully accept when the answer was no." I said, "I know." I said, "Let's file." Margaret retained a process server. The application was filed within 2 weeks. Daniel was served at his office on a Wednesday morning. Margaret told me later that his assistant had to interrupt a client meeting to give him the envelope. I thought about his face in that moment more than once. Gerald called me that same afternoon. He did not sound like a man making a practical proposal this time. He said I was making a mistake. He said I was making this harder than it needed to be. He said there were better ways to handle this. I noticed he did not say anything untrue, technically. Just threatening in the way that money talks when it doesn't need to raise its voice. I did not respond to him directly after that. I let Margaret handle all communication. The prenatal DNA test confirmed paternity at 22 weeks. It was a non-invasive test, a blood draw. The results came back within 10 days. The result was not a surprise to anyone, but documentation is not about surprise. It is about record. The court process was not fast. I want to be honest about that. It stretched across months. There were filings and responses and a case conference with a judge before we ever got to a hearing. Daniel retained his own lawyer, a senior family law litigator from a large firm, which told me something about how seriously Gerald was taking this, despite his calm exterior. Daniel's position, put forward by his lawyer, was that he was not employed in a salaried position but rather drew income through a combination of partnership distributions and dividends through a holding company. His declared income on his most recent tax return was $112,000. His lawyer argued support should be calculated on this figure. Margaret filed a motion for full financial disclosure. She filed a request for documents going back 3 years. Partnership agreements, distribution statements, corporate tax returns, the holding company's financial statements. Daniel's lawyer objected and delayed and filed responses to the motion that Margaret described to me as aggressive, which I understood to mean expensive and intended to exhaust me. I was not exhausted. I was genuinely more clear-headed during that entire process than I had been in years. Something about having no ambiguity about what I was doing and why made everything simpler. I went to work. I went to my prenatal appointments. I answered Margaret's emails the same day I received them. I slept 7 hours a night. I was fine. I should mention that I was, at this point, obviously pregnant. I told my manager at 12 weeks. She was kind about it. HR was professional. I am lucky in that respect, and I know it. Several of my colleagues, the women in particular, had the specific, knowing look of people who had navigated something similar and respected that I was not discussing it. My mother knew everything. She drove up from Hamilton twice a month and we made dinner together, and she did not offer opinions I hadn't asked for, which is the highest form of parental love I know. The financial disclosure, once the court ordered it and Daniel's lawyer ran out of procedural delays, was illuminating. Daniel's actual income, when the distributions from the holding company were properly included as the court determined they should be, was considerably higher than what had been initially declared. Margaret had expected this. She had told me at our second meeting that when someone structures income through a corporate entity, the first figure they offer is almost never the whole picture. There was a settlement conference. Daniel's lawyer made a revised offer. Margaret and I sat in a small room in the courthouse, and she showed me the number on a piece of paper. It was higher than the initial offer. It was still below the guideline amount on the income the disclosure had revealed. Margaret's expression when she slid the paper across to me communicated everything I needed to know without her saying a word. I shook my head. She went back out. She said no. She said we would proceed to hearing. At the hearing, the judge reviewed the financial disclosure in full. She asked Daniel's lawyer several precise questions about the holding company structure that his lawyer answered carefully but not completely. The judge noted this. Judges notice things. That is their job. The judge found that Daniel's income for the purposes of child support should be calculated at the figure Margaret had been arguing from the beginning. She ordered table amount support based on that income, plus a proportionate contribution to Section 7 expenses, which in Ontario cover things like childcare, health-related costs, and extracurricular activities as the child grows. She also ordered that support would be subject to annual income disclosure and recalculation. The order was made on a Thursday afternoon. I was sitting outside the courtroom when Margaret came out and told me. She was not effusive. She said, "The order is as we requested." She handed me a copy of the endorsement. I read the first paragraph standing in the hallway. "I called my mother from the parking lot," she cried. I did not, which surprised me a little. I think I had been so focused on the process that the conclusion felt less like a victory and more like a correction. Like something that had been wrong had been set back to where it should have been. Gerald did not contact me again after the order was made. I found out through a mutual acquaintance, months later, that he had referred to the whole situation as unfortunate. I thought that was a very specific word to choose. Unfortunate, not unfair, not unjust. Unfortunate like weather, like something that had simply happened to him. My daughter was born in November. She was healthy and loud and had a remarkable amount of dark hair for a newborn. I named her Clara. She weighed 7 pounds and 4 ounces. She came into the world in the early morning, and by the time the sun was fully up, she was asleep on my chest, and I was already, completely, a different person than I had been the day before. Daniel has exercised parenting time. It is scheduled, it is structured. It is managed through the parenting provisions in the order, which Margaret drafted carefully, and which a judge has signed. He shows up. He is not warm, exactly, but he is present, which is the minimum the order requires, and which I have decided is enough for now. Clara will make her own assessments of him as she grows. That is not my job to shape. I think about Gerald's offer sometimes. $400,000. I know what $400,000 would have meant for me practically. I am not naive about that. I live in a one-bedroom apartment that I share with a baby and a coffee maker, and more laundry than I thought one small person could generate. I count things. I watch for sales. I have a line-item spreadsheet for my monthly budget that I update on Sunday nights. But I also think about what that $400,000 was actually an offer to purchase. It wasn't a gift. It was a transaction. It was structured so that I would take the money and Clara would not exist. or would exist without any legal claim to her father's participation in her life. It was designed to make me smaller so that Gerald and Daniel could remain as they were, unbothered, unaccountable, unchanged. And the thing I know now, that I did not know that morning in Gerald's office, is that the unbothered life he was offering to buy me was a much smaller life than the one I was standing at the edge of. It just didn't feel that way yet because it came with a number on a page and a controlled boardroom smile. The law in this country is not perfect. Family court is slow and expensive and exhausting in ways I did not fully appreciate until I was inside it. There are people navigating that system with far fewer resources than I had, without a friend like Priya who knew to say call today, without a lawyer like Margaret who knew every procedural move before it was made. That is a real problem and I am not going to pretend otherwise. But the framework exists. The child's right to support exists independently. It cannot be signed away in a private meeting no matter how much money is on the table and no matter how certain the man across from you sounds. That certainty is a performance. The law is not. Clara is 8 months old now. She has learned to pull herself up on the edge of the coffee table and she looks extraordinarily pleased with herself every single time she does it. She is the most specific person I have ever met. She already has opinions about which songs she likes and which direction she wants to face in her career, and which toy is acceptable and which one is not worth her time. She did not cost $400,000 to keep. She cost exactly nothing to keep. I just had to decide she was worth the fight. She was. She is. That part was never actually the hard part. The hard part was understanding that a man handing you a document in a room he owns, with a folder full of legal language and a voice full of certainty, does not mean the document is right or the certainty is real. It means he has done this before, or he thinks he has, and he is counting on you to accept his version of the story because his version is faster and quieter and comes with a number attached. I had a different version. It took longer. It was not quiet at all, but it was mine. And it is still mine. Every word of it.